So, all right, everybody is here. This is unique. We have everyone. We have all of the online people plus all of the live people. This was actually the plan all along. This was going to be the class where I was going to bring my laptop to class and I was going to do that final review for everyone simultaneously. But unfortunately, because of everything getting pushed back and messed up and moved to online, we have an essay today, and that's going to make it a really awkward thing to do. So here's the plan of attack. In a couple of minutes, I'm going to let you guys go to do your essay. Now, live students, you have no choice. You have to log on to ExamSoft, you have to do your essay, and then an hour and 15 minutes later, you're going to log back on here and we're going to pick up the class and get into that review. Online students have a choice. In theory, you could not do the essays here. I think that would be a really bad thing to do. I'm begging everyone to please do them, like I said last night, because if you don't do them, that's a major problem from the standpoint of I'd love to talk about it with people tonight, but since you guys don't technically have to turn it into Sunday, I'm obviously not going to tell anyone what the answer is unless it says they've all been uploaded. So with that said, the good news is I have an extra class with the live class scheduled for next Wednesday, the 22nd, and we can always go through the essay at length then. It's a contracts essay that has a lot to do with performance and remedies, the stuff that we've covered over the last week. And I think it's a pretty fair one. I think it's pretty straightforward. You just have to use the facts. It's a real baby bar essay from a while ago. And it's one that might even be in your Fleming's materials if people have been practicing the Fleming's materials like I've been begging them to do. So I wanted to go with one that wasn't terribly tricky. I just wanted to get you where you needed to be. Now, here's another thing we got to discuss. For the final exam, because of everything we just talked about, for the flex skills, I actually don't have a big problem with it being 3 essays. And there's a reason for that. There's 3 subjects. This way I can test you guys in each of the 3. For substantive core classes like torts and contracts, I wish that circumstances were different because I would like to give multiple choice questions in those subjects. So it would be essay, MBE. But as it stands with the current format and the current guidance they've been given, it looks like it's going to be 3 essays, 3 essays, 3 essays. Now for us, that's easy. 1 contracts, 1 torts, 1 crime. Now the contracts essay, I'm going to focus on first semester stuff because you're already getting tested on second semester stuff in that class. And the torts essay, I'm going to focus on first semester stuff because you're already being tested on second semester stuff in that class. Now, I told my students that have me for torts, I told you exactly what I think is important for your finals. I told you what the big issues are for me. I told you look out for strict liability, products liability, defamation, invasion of privacy, and that other stuff can sneak in there as minor issues. But if I made a handout about it, you better know how to follow that handout. That's torts. In contracts, I'm not hiding the ball. I'll tell you guys what's coming in the contract class tomorrow. In this class, there's 3 different subjects covered, and each class is going to be covered. There's going to be a crimes essay. I'd be looking out for big stuff like murder. There's going to be a torts essay. I'd be looking out for stuff like negligence. And there's going to be a contracts essay. I'd look out for a contract formation with a bunch of communications back and forth. So that's what's coming as far as your essays in here. Now, here's where this gets really weird. 8 of you are going to have the final on one day, and 20 of you are going to have the final on another. So this is where we need to make sure that communication is kept to a minimum. And it's just really, really, really weird that it's being done that way. It wouldn't have been done that way if not for the circumstances that are going on. So my understanding is that my online folks who are here today, you guys are going to be having that final coming right up. My live people, you're not going to have it until we get into May. Is that correct? So that's why I have everyone here at this review today. I wanted to stagger them and do 2 reviews, but if I did that, then my online people wouldn't have a chance to have a review before they have their final. Live folks, I'm not too worried. You get another chance next week. Online people, you're welcome to join us, but I think you might be done with some of your finals by then. But it can't hurt to be a party to it. So with that said, tonight's exam has been posted by Professor Ironcastle. I need to let you guys go to it so you can get back and we can actually wrap up and do that review. I did not intend to have an essay during our final review. Like I said, unfortunately, circumstances in the whole world are crazy right now. And I guess having to cram our review into a week that has an essay, all things considered, is a minor sacrifice compared to some of the stuff that's going on right now. So with that said, let me give you guys the password for that essay. I have so many emails from Trinity today. It's not even in my first page of Trinity emails. Okay. The exam number is A6745T. 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 So my initials sandwiched around 6745. Let me put that on chat. A6745T. Now, I'm going to let you guys bug out so you can log in there and do it. Everybody, I know that it closes you out of everything else when you get on ExamSoft. So as soon as that essay is done, oh, Kristen, you guys don't have it until the 6th either? Oh, good. Oh, awesome. So that's it. Okay. So that means that next week on 4/22, we can do another more in-depth review without a dumb essay getting in the middle of it. So we can actually go through each of the 3 subjects, a rundown of what I think is important, and then answer the question. So thank you, Kristen. I did not know that. When I tell you guys that I don't know when things like finals are because I don't get those emails, I am not kidding. I did get all the ones today through the portal about grading, and I get them from Professor Ironcastle because she's very communicative. But from the general administration, you guys from my live class, you know I am not kidding. That last time we met live, I was in class and did not know that we were allowed to do classes remotely because of the virus. They did not send me that message. So you guys realize, I thought you were joking. People, my online people probably don't believe me. I thought they were messing with me when they told me there was an email that said that we had the option to do class from home. And I actually went upstairs and tracked down Mr. Stalnecker to ask him if it was true. And he just looked at me like I was crazy. So yeah, and I need to get a portal page. And I'm actually going to bring that up on Friday in that meeting. I can't be out of the loop with important things. This is something that has to change as finals are coming up. So, all right. I'm going to let you guys log off. It's currently 6:45. I'm going to give you an hour and 10 minutes. It's not actually 6:45 yet. I'm going to give you an hour and 10 minutes. At 7:55, I want everybody back here. At that time, I am going to pop onto ExamSoft by pretending to be Maria. I'm going to make sure everyone finished the exam. If you guys all finished the exam, then I'm going to tell you what I was expecting on the exam. If people have not turned in the exam yet, then we're going to go right to the final review, and I'll wait till next week when all the exams are in to tell you what the answer is. I obviously, you guys understand why I have to do that. If they're not turned in, I can't say, oh, these were the issues. This is what I was looking for. And then magically everyone gets hundreds. So that's the problem with having 2 groups consolidated into one. So you guys have an hour and 10 minutes or so. Good luck on the essay. I'm not going to be looking for anything too crazy. I just want to see if you use the facts and see the big picture issues. Good luck. Get to work. And I will see you guys in 1 hour and 10 minutes. I'll be sitting right here. So welcome back. Most of you are back. We've got 19 people. So here's the deal. All 19 of my live people did the exam. So as soon as we're done, I'm going to go through them. That's good. That's great. They all uploaded. There's no issues. Unfortunately, in the online group, only 2 people have uploaded it. So I can't very well say what the answers are and have people then do that. That really is unfortunate. I don't get it. I honestly don't get it. Yeah, 2. I keep hitting refresh. 2. So all 19 of the live folks have it done, but only 2 people turned it in as far as the online group. So let me just check it one more time. Yep, 2. All right. Well, that takes us out of the realm of being able to discuss the answer to the essay. I have my thoughts ready to go, but I can't actually say anything because 5 people still haven't written it up. So anyway, here's the deal. As soon as you guys log in next week, 1 week from tonight, first thing I'll do is I'll take you through this essay. I can't say anything about it because people haven't done it. I begged, I pleaded, that's all I can do. So we'll have to do it next week, first thing. And don't worry, you will get, if you did it tonight and you're in the live class, you'll get my write-up telling you what I think. So as soon as we're done, I'm gonna just shift gears and start grading that. So, okay. That brings us to our review. And what are we going to be doing in here? Well, as of right now, and I really don't see things changing again unless something happens on Friday, you guys are going to be getting an exam that is going to have 3 essays, 1 essay in each of the 3 subjects. 1 is going to be torts, 1 is going to be contracts, and 1 is going to be criminal law. Now, with that said, for torts and contracts, because you still have those classes as active classes, I think the best and most logical thing for me to do is test you on essays that largely fixate on first semester concepts. That doesn't mean it won't touch on second semester stuff, but I think the big thing is probably going to be first semester stuff. Now, from criminal law, anything goes because there was only 1 semester of criminal law. So what I'm going to do for the next few minutes here is I'm going to run you through everything that you should remember. And then I'm going to open it up to questions. And then I'm going to let you go earlier than usual because I'm going to go grade those essays. And I'm going to see you all next week for you guys to bring your questions. And by then the final should be created unless they change the rules on Friday. And then I can be more specific. So with that said, everything it says in the syllabus can pretty much go in the trash because it's going to be 3 essays, 1 per subject. So that's the first thing. Okay, hang on. Let me mute some other microphones. So with that said, what we're going to be going through is crimes first, then torts, then contracts, just to tell you what I want you guys to have remembered. So in criminal law, remember your fundamental observations. Your stuff like being able to differentiate between the specific and general intent crimes, Remember which ones get which defenses and all of that good stuff. Remember the elements of crimes when all else fails. You know, every single crime has at least two elements: a physical act and a mental intent. And if you actually know the elements, it would make life a lot easier. So, first big testable concept in crimes is your inchoate crimes. So remember in the inchoate crimes, that's SAC, solicitation, attempt, conspiracy, and accomplice. Solicitation, encouraging somebody to commit a crime with the intention that they actually do it. It's a specific intent crime. It merges if the crime gets done. Remember that attempt requires a specific intent to do the crime plus an overt act in furtherance. Got to have both. Remember that with attempt, you have the defenses of legal and factual impossibility. Majority of jurisdictions, legal impossibility gets you off the hook. Factual impossibility isn't going to help you. We don't care. Now, with attempt, no matter what the attempted crime is, the attempt in and of itself is specific intent. So even if the crime they're attempting would have been a general intent crime, I don't care. In general, we're talking about a specific intent crime. So that's attempt. Now, as we move into conspiracy, got to have the agreement between two or more people. You have to have an agreement to commit a criminal act. There needs to be an overt act in furtherance in most jurisdictions. And remember that if you're raising conspiracy, the whole point is typically to get to Pinkerton. All co-conspirators are responsible for any crimes that are foreseeably committed in the furtherance of the conspiracy. Now remember that when it comes to conspiracy, there is the special defense of withdrawal. And again, remember that modernly, most jurisdictions, in order to effectively withdraw, you not only have to abandon it, you also have to take proactive steps to prevent the crime from happening. So withdrawal doesn't work very often. So that is solicitation, attempt, conspiracy. Accomplice liability, if you want to fixate on that a little bit, I would spend time understanding the difference between common and modern law. Common law, we had before the act, at the scene, after the fact, and they were all guilty essentially of the crimes of the principal actor. Modernly, accomplice is its own charge, and you have to actively aid somebody in committing or getting away with a crime with the specific intent to help them. So modern accomplice liability is a lot more simple. Common law, you got to go through all of the three different stages and describe which one it is. Those are your inchoates. That's what we spent our first week or two going over together. Then we moved into the crimes against the person. We talked very, very briefly about assault, battery, mayhem. We talked a little bit about rape and kidnapping, only in so much as they come in as underlying felonies for the felony murder rule. And what we really spent our time on is the homicide approach. And by now, if you can't write the homicide approach, I don't know what to tell you. You got to be able to do the homicide approach. It's quintessential. So when I'm talking about the homicide approach, what am I talking about? We're talking about you start with homicide. There's the elements of homicide. It's the killing of another with actual and proximate causation. You need to actually go through the actual and proximate causation, but for and foreseeability. Once you have a homicide, then we look to see if our homicide gets bumped up to murder. Yep. How do we bump it up to murder? Well, murder is homicide with malice aforethought. That means you need to add malice. How do you add malice? There are 4 ways you can find malice: intent to kill, great bodily harm, depraved heart, felony murder rule. Your rule should tell me all 4 ways, and then your analysis should only analyze the ones that apply. So intent to kill, great bodily harm, depraved heart, felony murder rule. If there is no malice, your analysis is done. Our homicide is involuntary manslaughter. If there is malice, you have to continue. First things first, You qualify it as a murder. Then you move on and decide whether it's murder one or murder two. What's murder one? Premeditation, deliberation, plus specific intent to kill, or the felony murder rule, or poison, bomb, torture, ambush. What's murder two? Anything else. So once you've decided it's murder, look to see if it escalates to murder one. If not, murder two. Now, once we've decided which degree of murder it is, we go on to the last step in the homicide approach, and that is defenses and mitigations. Look to see if any defenses apply first. What are our defenses? We have justification and excuse defenses. Justification would be things like defense of others, self-defense. Excuses would be things like intoxication, insanity. Those are our types of defenses. After we look at defenses, the very last thing in the murder approach would be mitigation. Mitigation could be either heat of passion or imperfect self-defense. Heat of passion requires an analysis of all four elements. No reasonable time for a person to cool off. Defendant did not, in fact, cool off. Adequate provocation that would make a reasonable person kill. Defendant was, in fact, provoked. Imperfect self-defense. Remember, the person honestly believes they're in danger, but their belief is unreasonable. You might also want to bring up diminished capacity, but remember, that's only a partial mitigation.
Yeah, that's true.
Now, once you've done the murder approach, it's so easy. You just do it and you maximize your point value. Homicide, causation, malice to murder, no malice, it's invol. If there is malice, is it murder one or murder two? Look for defenses, look for mitigation. It's that simple. Just follow the approach. After the crimes against people, we have the theft crimes. And the ones we went through were larceny, taking personal property of another with the intent to permanently deprive them. Embezzlement, which is fraudulently converting someone else's property to your own use. It's just like larceny. The difference is you've been entrusted with the property, so it wasn't a trespassory taking. We covered receipt of stolen property. We covered robbery, which is larceny plus force or threat of force. And we covered larceny by trick, where you trick someone into giving you possession. And we differentiated between that and false pretenses, where you trick someone into giving you title and an ownership interest. With the theft crimes, we also learned our habitation crimes, the two crimes that require buildings, burglary and arson. And the whole point there is to understand the difference between modern law and common law. Common law, burglary had to be the breaking and entering of the dwelling house of another in the nighttime with the intent to commit a felony there within. Modernly, entering a structure for a criminal purpose. They've relaxed it a lot. You go into Walmart to take a pack of gum, you're guilty of burglary in California. Arson, same thing. It used to be the malicious burning of the dwelling house of another. Now it's burning something down. Arson has become a lot easier under the common law. Under the modern law. After we talked about burglary and arson, we moved into our last unit in crimes. Our last unit in crimes with defenses. We talked about voluntary and involuntary intoxication. Voluntary is only a defense to specific intent crimes. Involuntary is a defense to all crimes. We talked about insanity. You need to know all four standards. McNaughton, irresistible impulse, Durham, and the American Legal Institute Model Penal Code rule. We talked about the self-defense type justifications, the same ones that you'd use under a homicide approach. This is defense of others, defense of self. Remember, defense of property is never going to be enough to use deadly force. And we talked about some of the other weird ones that can come up, like infancy, which can occasionally come up. Duress, consent, entrapment, all stuff I'd keep in mind. And that was what we did in criminal law. We took about a third of the time. We took about 4 weeks dedicated to criminal law, and that's how we broke it down. We started with the inchoates. We moved into homicide. We then took on theft and buildings, and then defenses. So those are the 4 units in criminal law. Those are the 4 big broad areas that I'd expect my test to come out of. So that's what's coming in criminal law. Everyone should have that colorful 1-page guide. If it's on here, I recommend you know it. And if it's on here, it's fair game. If I can boil it down to 1 page, I don't feel guilty pulling anything off the page for the exam. I think that's fair. So that was our first subject that we did together. Second subject, we moved into torts. Seems like a year ago that we did criminal law, doesn't it? It's like a different world. So torts, again, we broke up into 4 or 5 weeks. I think we took 4 weeks on torts. And the breakdown for torts was intentional torts and negligence, strict liability, products liability, and defamation, invasion of privacy. So that was the way that we broke down torts. Those were the 4 overriding units. So let me tell you guys what's fair game in torts. First and foremost, I recommend you know your intentional torts. They're super easy. I don't know that I'd want to test you on something that easy, but I might. That means ABC fit, assault, battery, conversion, false imprisonment, IIED, trespass to land, trespass to chattel, ABC fit. Remember your elements. If you guys have that page I created for you and I asked you to write the elements next to each intentional tort, you should have it handy in a 1-page reference. If you have an intentional tort, don't overlook the defenses. The big ones are self-defense and defense of others, privilege and consent. Consent can be either express or implied. Implied is based on the circumstances. Privileges we talked about quite a bit. Privileges and immunities for my online people. That was what that was when I took over for Professor Erskine, so that should be fresh in your minds. We went through 14 fun cases about it. Remember that? I still couldn't believe there were 14 cases in 1 week. I will say this. I had some professors that were draconian that dropped 250-page reading assignments on us. In fact, I had quite a few of those.
Oh no, McCarran.
There was a guy named Rosenthal, there was a guy named Hewitt. But usually it would be a lot of background and understanding type stuff and just a couple of cases. Rarely would it be like 14 cases. The only class that was like that, where we averaged about 10 cases a week, was constitutional law. But that makes sense because there is no restatement or anything. All of the law comes from cases interpreting a couple of page document. So you have to know the cases in constitutional law. But we made it through the 14. So remember that when you're writing intentional torts, you better use perfect IRAC. If I do give you intentional torts, I'm not saying I will, but I need perfect IRAC. Head note the tort, give me the elemental rule statement, apply the facts to prove or disprove each element, and once you're done, conclude whether or not that tort has been satisfied.
Yes, sir.
Now, the second thing that we covered was negligence. And negligence is a lot more likely to be tested. Now, negligence could be basic negligence, someone's driving like an idiot. Negligence could be something like professional malpractice. Maybe a doctor leaves the scalpel in at the end of the surgery, which I know someone who just did that at Kaiser Permanente.
What?
And then they lied about it to try to cover it up. And the interesting thing is they turned it from a malpractice thing into a criminal thing. So anyway, long story short, negligence could be anything from 12-year-old Charlie driving his broken ATV stupidly. That should remind some people of something. All the way to a professional not living up to their professional standard. Why am I pointing out the broad scope of negligence? Because the first thing you guys need to do is establish the duty. And remember, what the duty is depends on who the plaintiff is and who the defendant is. So you got the general duty, which is to be reasonable under the circumstances and not create an unreasonable risk of harm to others. But we've also got all kinds of special duties. We've got the special duties where an omission is a problem for teachers, common carriers, police, doctors, parents, spouse, etc. We've got landowner occupier duties, and they're different, whether it's a trespasser, a social licensee, or a business invitee. Do you have to warn them? Do you have to fix things? Depends on who they are. Luckily, I gave you guys a piece of colorful paper again with it exactly written out. We also have negligence per se to establish the duty and the breach, but that requires a violation of a safety statute causing the kind of harm that the statute was created to prevent, and the plaintiff has to be the type of person that's sought to be protected by the statute. Once you establish the duty, you explain the breach. And this is where most of the essays I've gotten this year have been really lazy. First, you explain what the duty is, then you have to use the facts to explain to me why the defendant did not live up to the duty you established. What did they do and why did it fall short of their duty? If you're not fully doing that, you're not getting full breach points. After the breach is actual cause. This is the easiest part. If there's only one defendant, it's the but-for test. If there's multiple causes, it's the substantial factor test. Then you move on to proximate cause. Don't be lazy, get full point value. Explain whether the injury was foreseeable. Explain whether the plaintiff was foreseeable. How do we know if the plaintiff was foreseeable? They were in the zone of danger, or under some jurisdictions, they were in existence. That's our split. Now look out always for intervening causes. Something that happens after defendant's dumb act that contributes to the ultimate injury to the plaintiff. If you find an intervening act, you need to look at it to decide whether it's intervening or rises to the level of superseding. What is superseding? Superseding is an unforeseeable intervener. This cuts off the defendant's liability. Finally, the last element of your negligence case is harm or damages. And once you have that, you look for your defenses. You have a couple of defenses that you always want to try to apply if they're there. Contributory or comparative, depending on the jurisdiction. Remember, comparative can be either strict or modified with the 50% rule. And last but not least, assumption of the risk. So 3 defenses to run through every time. Contrib, compare, assumption of the risk. For tort classes, that was probably all of your first semester stuff. Then we moved into strict liability. And strict liability is either animals or abnormally dangerous activities. If it's an animal, they're either wild or domestic. If you're Joe Exotic, your wild tigers trigger strict liability, except there's an exception for you because you are a zoo, and zoos get negligence because of public policy. Otherwise, zoos wouldn't exist. So that's wild animals. Domestic animals, the basic rule is you judge them by negligence unless they have a dangerous propensity. What is a dangerous propensity? The 1 bite rule. If that dog bit someone before, now you're strictly liable. If we had no way to know it was aggressive, then negligence is the standard. Finally, trespassing livestock is strict liability. As I've said before, trespassing livestock is not some all-encompassing, overblown thing. This is literally the livestock leave your land, trespass on the land of another, and by walking on that land cause damage to the land. Not kicking people, not biting people, not clawing people, damages due to trespass. They step on your flower garden. If you don't have facts like that, don't go there. Now, if you decide that strict liability applies because there's a wild animal or a dangerous domestic animal with propensities, then you move on to actual cause, proximate cause damages. Strict liability can also apply with abnormally dangerous activities, aka ultra hazardous activities. How do you know if the strict liability standard applies? You balance 6 factors and decide, what are the 6 factors? How likely is it to go wrong, aka degree of risk? How bad will it be if it does go wrong, gravity of risk? Can you make the activity safe? Is it a matter of common usage? Is it being done in the appropriate place? And what is the value to the community? Those are the 6 factors. You look at the utility of what they're doing versus the risk of what they're doing. If utility outweighs risk, negligence standard. If risk outweighs utility, strict liability standard. That's how we do abnormally dangerous activity. Again, you guys got the nifty one-pager on this. Okay. The next thing we covered is products liability. Remember to take it step 1, step 2, step 3 to maximize point value. You always start with negligent products. It's fun and easy because you do it just like any other negligence. Start with the duty, make a safe product. Move to the breach. That's where you explain the defect, whether it's manufacturing design or failure to warn. Actual cause, proximate cause, damages, defenses, just like any other negligence. Then you move on to warranty and you discuss any of the 3 theories that apply. Express, only if there's an oral or written one. Fitness for purpose, only if the seller knows why the buyer is buying it and says it's safe for that. The only one you have to write about every single time is merchantability. That means that the product is safe for average reasonable use. That's your duty. Then you go down to breach, ACPC damages, and you supra all of that. You copy and paste it right out of your negligence. That's why you do negligence first, because you're going to supra all of that from breach on. 2 defenses that you can use: assumption of the risk and unforeseeable, unreasonable misuse of product. Finally, your last theory is strict liability and tort. You start out by making sure we have a proper defendant. That's a seller, manufacturer, distributor. You make sure they placed that defective good into the stream of commerce. You make sure it was already defective when it left the defendant's hands. Watch out for the sealed container doctrine to indemnify manufacturers. And if the defect causes injury, you're strictly liable. Same 2 defenses of assumption and misuse apply. Page 40 of the Brown-Fleming's book has a perfect example of how I want you to write this issue. I'm telling you now, if you're an online student, there are 7 of you here, you will be tested on this issue in your torts class. I'm not going to say if you're going to be tested on it in FYLSX Skills, but if you're an online student and I took over Professor Erskine's torts class, I am telling you with 100% certainty, you are getting a products liability essay, because the ones that we did during the semester were honestly kind of a dumpster fire. So it's kind of a chance to build on that and make them better. The last unit we had in torts was defamation and invasion of privacy. Defamation requires a false statement, untrue statement of fact. It's got to be defamatory, which holds you to contempt or ridicule. It's got to be published to at least 1 third party. It's got to be understood to be about plaintiff. And sometimes you need to prove damages. Depends on the situation. If it's libel, which is written or recorded, the damages are presumed. If it's slander, the general rule is you got to show money damages, unless it falls into one of the 4 slander per se categories. Those are so offensive, you don't need to prove your damages. And we have an acronym for them. It's CLUB: crime, loathsome disease, unchaste woman, and shady business practices. So we've got some special provisions. Remember that if you intentionally defame someone, you can get punitives. Republishers are liable, and retractions can reduce damages but not eliminate them. We have a couple of weird defenses that we got to go through for defamation. Some of them are obvious, some of them are more tricky. So the obvious ones are consent and truth. Absolute privilege is pretty straightforward. There are certain places where you're allowed to speak freely. You can't be sued for it. Congress, courtrooms. qualified a privilege, which applies when you are protecting the interest of others by giving a consumer report. Like if you go on Yelp and write something, you're somewhat protected. The limitation on your protection is you're not protected if you act with malice. If you're knowingly and intentionally lying, you're not protected. If I say that I've left my house for a grand total of 1 hour in the last 3 weeks, and I'm so bored that I'm hallucinating, so I went to Amazon and bought a Lego kit, which I haven't done since I was like 10 years old, from some seller, and they sent me my 2,000-piece Titanic, and the shipping company they used, called One Stop Mailing, lost it somewhere in Los Angeles a week ago. And then I called them and they were really rude to me. And then I called them again and they told me, too bad, so sad. And they called me a third time. I called them a third time and they promised to give me an update and they haven't for 2 days. Then if I went on Yelp and I told everyone that they were the worst shipping thing ever and that I would have trusted it more if they sent it by carrier pigeon, and that the people I've heard from are more incompetent than the people running the government's coronavirus task force, then, and I'm saying that talking about the way they started it, now they're starting to get on the record. But you get what I'm saying. My Yelp review would not be defamatory because I have a qualified privilege to protect other people from using one-stop mailing services. You can see my one-star review on Yelp for one-star mailing services. But anyway, the point is, if you're trying to protect other people and you're not malicious, you're okay. Now, on the other hand, if you lie and you're malicious, you're not okay. That story I just told you was actually true. This place was ridiculous. They were rude. They hung up. The woman who I spoke to on the phone, when I asked him, it's been at your place for like 2 weeks now. The seller gave it to you immediately. I live 90 minutes away by car. Why don't I have it? What is going on? Her excuse was, some people are working from home right now, so we can't track it. I thought you just scanned it with a computer and then threw it in a mail bin or something. So I don't know. The point is, everything I said was true. I'm not telling you guys about this. I'm using this as a real example of qualified privilege because I wrote that earlier today. So qualified privilege, if you're trying to help people with consumer protection, you're protected, but not if you lie. I have 2 cases about this where you're not protected. One of them from someone I know, and one of them is a news story I read that was interesting. So there was a restaurant that was opening up in a town, and I guess the people that were running the restaurant were very politically oriented. I honestly don't remember on which side of the spectrum. I just know they were really vocal. And because of that, there were people that disliked him. I don't know if they were like super conservative, super liberal. I don't care. It's not the point. The point is, some people went on Yelp before the restaurant even opened and started writing ridiculous reviews. I went to eat there and there were bugs in my salad and they stabbed me with the fork. Stuff like that. Well, the restaurant owner is like, we're not scheduled to open for 10 days. I'm pretty sure you didn't come get bug salad. That ended up being a lawsuit, and that person was liable. That was defamation. There was no consumer protection because it was 100% malicious. You see the difference? Same thing actually happened to one of my really good friends. Samuel, I'll tell you the story. I'm telling it to everyone, but I'm telling it to you because I think you're working in the office where this person might work now. So I won't use her name. But there's a woman who now works at OCPD's office who used to be like my little protege. If you see her, she wears purplish glasses. She's thin and has dirty blonde hair. Just so you, but no one else on that.
Okay.
She had a client once who was a drug dealer who propositioned her many times and hit on her a lot. And finally, she lost it on him. It was just like, I'm your lawyer. I represent you. I'm helping you with your case. Do not act inappropriately like this, essentially. And eventually, well, she didn't say it like that. If you know who I'm talking about, then you know there were a lot of F-bombs and a lot of like screaming. So anyway, After she did that, he pled out, whatever, he disappeared. He was mad at her for, telling him to stop being a jerk. He went on the lawyer version of Yelp, Avo, and wrote a bunch of stuff like, oh, she's incompetent. She intentionally screwed up my case. She wanted to have sex with me instead of do my case. He wrote all of this stuff. And then he was so dumb that he used his email as his profile, so it didn't even hide it well. The reason I'm telling the story, Avo wouldn't take it down for a while. Avo was very, we're not taking this down. We want people to be able to freely write things, until she got an attorney that went to school with us to write them an email saying, like, this is provably false. This is demonstrably false. In fact, his case got dismissed. It couldn't have been handled any better. And if you don't take it down, we're suing you for defamation. It was down within 16 minutes of sending them that message. So the idea is, why am I telling you this? Republishers are liable. If I write something defamatory on Yelp and Yelp knowingly leaves it up, like that case about the people who said there were bugs in the food at the restaurant that wasn't open, Yelp is responsible. You guys get that? So that's something that might come up on an exam. I'm just saying. So anyway, finally, there's First Amendment privilege. If you're talking about a public figure, a politician, or a famous person, the standard they have to prove to win a defamation case is virtually unattainable. It's actual malice, which means knowing falsity or reckless disregard for the truth. And that's a very tough standard for them. That's why you typically don't see celebrities suing America for defamation. England uses a regular standard of negligence, and that's why you always see those lawsuits filed in England. But here, it's an actual malice standard, which is very, very difficult. The only person I know who actually wastes their time trying to sue tabloids is Donald Trump. And of course, that never actually goes anywhere. They always get dismissed immediately, especially considering that since he's the president and he's a government operative trying to silence them, there's this little thing called the First Amendment. But that's another story for another day. Now, finally, we moved on in March into the fun world of contracts. And contracts is where we were up through last week. Now, in contracts, there are a couple of things I want you guys to be rock solid on. First of all, formation. Now, my live students, you had a formation essay a few weeks ago and you did a great job. I was very happy with it. So keep up the good work. Formation, you have to tell me the applicable law. You have to go through each communication one by one, figure out where's the offer, is there an acceptance, is there rejection, revocation. You just go through each communication one by one. You guys know how to do that. So online, folks, well, we talked about that a lot in our last contract class. I'll leave it at that. We'll see how today's contract essay turns out in a little bit. After formation, we talked about third-party bennies. We talked about how to draw the triangle. You have to figure out, are they intended, creditor or donee, and have their rights vested. Step 1, step 2, step 3. If you want to follow the mnemonic device from Fleming's, that would be depraved. Define it, look for the privity, etc. But if you want to simplify it to make sure you get through it on the exam, just 3-step it. 1, 2, 3. Intended or incidental, creditor or donee, have their rights vested, and that's how you know who they can sue. Simple. We talked about assignment and delegation. Remember, assignments are typically okay unless they change the obligations. Delegations are not okay if it's a unique, personal, special skill. We talked about performance. Performance was a long class. We went through great length of explaining I'm for Sandy and swap die. We talked about conditions and covenants. We talked about swap die for how you can satisfy or excuse a condition. We talked about for I'm for Sandy for how you can get out of having to perform your covenant. I'm not going to take you through all 18 of those mnemonics. You've got the outline. Just remember some of the big ones. like impossibility, impracticability, frustration of purpose. One of them that you see an awful lot is anticipatory repudiation. That stuff, definitely, you need to know it. Last thing we talked about together was remedies. I gave you guys a handy reference guide for remedies. I gave you the money damages, I gave you the court orders, and I gave you the quasi-contract. So generals and how to calculate them, specials and when you can get them under Hadley versus Baxendale, incidentals, which are your out-of-pockets. We talked about specific performance, but only for land or very unique goods. We talked about undoing contracts with rescission. We talked about reformation to reform the contract to the party's true intentions. And we talked about our two QCs, quasi-contracts, where you don't even need a contract, reliance and restitution. So that's what's fair game. The stuff that I've spent the last 47 minutes babbling about, 15 minutes per subject, not bad, that's what's going to be on your final. So between now and that May 6th date, which I guess is when it's going to be, I would really encourage people to go through their handouts, bust out the Brown-Fleming's book, and, you know, try to write some of those essays as practice, maybe with the handouts in front of you to get you in the rhythm of doing it right. And when it gets closer to May, since you still have weeks, try to write it without the crutch and see how it goes. So that's what I'd recommend. You guys have a ton of time. Now, here's the beauty of this. All of you get one more final review session if you want it. 19 of you don't have a choice. You have to be there. The rest of you have it if you want it. Next week, same time. What I want you to do next week is to take a sheet of paper, make a list of questions, come to class and ask me your final questions. It'll be like Who Wants to Be a Millionaire, except I don't get anything. And I don't know the answers and make them up. No, that's what we're going to be doing next week. So next week when you log in, the first thing I'm going to do is I'm going to take you guys through the essay from today. I came unbelievably stupidly close from saying the blank essay from today and telling people what the issue was, but I caught myself. For those of you who already took it, you know exactly what it is. I don't think the issues were terribly hidden. I think it was actually a great essay. Unfortunately, 5 people haven't done it yet, so I can't say anything about it. So next week when you log on, I'm going to talk about that essay, and then we're going to go right back into final review mode. If all goes well, and this meeting that I'm having on Friday doesn't change the rules, I'm going to plan on wrapping up putting your final exams together on this weekend. It's not like I have anything better to do. I don't even have my Legos to build. So I'm going to try to put your final exams together this weekend. So with that said, let me open it up to questions now. Any questions about anything? This might be a good time to ask.
So if all goes well this Friday, it'll be 2 essays in the MBEs, but if it does not go well, it's going to be 3 essays?
No, opposite. Plan on it being 3 essays, 1 in each subject. I don't think we're going to be able to realistically revise how the MBEs would have to be done. What I'm afraid of with the meeting is, and I have no idea, I'm just going off of the fact that I hear chatter and I have ears, I wonder if they're going to be talking about throwing around things like a pass-fail. I wonder if they're going to be talking about how to do open book, what software to use. I'm not really sure. Now, if it was MBEs and 2 essays, the final would already be done. I already put together the 30 MBEs I wanted to do. I had 10 from each subject. It would be so easy for me to just email that Word document to the school and say, here it is, and give them the Scantron. But I don't think I can do it. I think it has to be, the professor has to log in to ExamSoft, create each one as its own special, 30 different questions, and then type each one with the formatting, and then create a rubric with the answer for each one. And I'm just being honest here. Aside from the fact that I literally don't have an account on ExamSoft, and would have to be pretending to be Maria logged in that whole time and then have her transfer it into me, into my exam. The sheer timing of it, you guys know, you've seen me try to use ExamSoft in class that one day when we were having issues accessing things. I don't even know the logistical nightmare of how that would work. So I'd be very surprised if you get anything other than essays on the final.
If it does change, can you email us on Friday?
So if anything changes, I'll email you guys Friday. But for now, I'd be planning on 3 essays. Now, here's the deal. Even if it's 3 essays, here's something I will do for you guys. This will not in any way, shape, or form count for a grade. But just because I want to help you guys get ready, because you might have the baby bar at some point in the near future, I will then, after the final, give you my 30 MBEs anyway, and let you take them and use Zoom to ask me questions, and I'll talk you through what I was looking for. Because at the end of the day, I told you the very first day you met me, I had one goal. And what was that one goal? To put people in position to pass the baby bar. So even if it doesn't count for a grade, I recommend you take them seriously. I'll send them to you. I took the time to make them, so they're sitting on my computer. So with that said, my understanding is we're still planning on doing that writing workshop in May. I think, I hope. I haven't heard anything about it. Have you guys? Yeah, neither have I. I think that we're still planning on doing that. So even though there's no conceivable way there's going to be a live baby bar in June with California's protection orders, I still think we should be preparing as though there is. Because what I think is going to happen, and I don't know, I talked to a woman at the bar. In fact, I'll even show you her text message. So I'm not kidding. I've been texting back and forth with someone who works for the bar. And this is what she told me about the exam. She can't say anything officially because obviously they haven't made any official decisions. I heard we are exploring a couple of options. One is postponing it until August or September, right before live schools would be scheduled to start. And the other is canceling altogether and allowing people to simply move to year 2, knowing that the bar will ultimately weed people down. The thing is, postponing it goes against the state's current orders and would interfere with people starting next semester. And on the other hand, if we simply let everyone move on, this would cause problems down the road for schools with certain bar pass qualifications, etc. And as a result, there are logistical nightmares there as well. Anyway, it's whatever we do, we're going to make some people really mad. We'll see what happens and play it by ear. I'll let you know if I hear further. So you see, I'm not kidding. I've been texting back and forth. So if I hear anything, you guys always hear everything I hear, even if you're not supposed to. So anyway, so for now, you're planning on this final exam being 3 essays, 1 torts, 1 contracts, and 1 crimes. The crimes is going to have a murder. The torts is going to have negligence in some form or another. And the contract is going to have formation. I don't think I can be more honest than that. So any last minute questions before I let you guys get out of here? All right, I certainly don't see any. So don't leave yet. Remember the rules. I have to take roll before I let you log off. So if you guys want to do me a favor and turn on your camera for like 30 seconds rather than making me call everyone's name, I'll just check everyone off. All right, Alex, Sonia, Juan, Michael, Nancy, George, Samuel, Amanda, Alan, Vincent, Polina, 1, 2, 3, 4, 5, 6, 7, Lawrence. Okay, perfect. I got everyone. So thank you guys for coming, and I'll see you all next week. Live people, I am going to go ahead
Mr.
and
Markby, absent?
no, this is for the live class. You guys are on a
Oh.
live class people have a different standard. I have to actually use a roll sheet and keep track of who's here every time. You guys, it tracks you automatically when you log on to the system. So otherwise, I might have gotten confused. Instead of Ildefonso, I would have had Amanda here. So could have caused some problems. But no, you guys are good. I'll see you guys next time. And I will just let you know what happens on Friday. If you don't hear anything, it means 3 essays. If I have news, you'll be updated. If it's pass fail or something like that, you'll be updated. If they're going to make you all sit in a room and take it and make you wear masks or something, I won't be there, but that won't obviously happen. That happened at one school. You guys hear about that Liberty University or whatever they call themselves? Sometimes you just don't, I just don't understand people, but yeah, no, you guys are going to be safe. I actually think, since some of you, you're almost all still here, I actually think the meeting is going to be less about this year's finals and more about the plan of attack going forward, because I heard through the grapevine that the plan is, I don't know, this is not Trinity, this is another school, but the other school, which I'll just say it's Chapman, I heard the plan there is that everything's going to be online until there's a vaccine. That they just can't put 120 people in a room. It's just not feasible. Professors don't want to be there. I can tell you guys from firsthand experience, teaching this class in room 102 with 21 of you in that small of an environment, I honestly think that if one person was sick, all 22 of us would be sick. So I get it. I totally get it. I'm wondering, my guess is that Trinity is going to be moving things online. It's a guess. I have not heard anything. But if that's the case, that's going to be very interesting because we're going to have to figure out how to schedule classes so there's no overlap. So it's going to be a very interesting meeting. And if anything happens that you guys need to know, I will tell you by email ASAP. If you don't hear from me, it means that everything is status quo. Thank you guys for coming. My 19 or 20 live students that are still here, I'm going to go grade your essays as soon as I get something to eat. So be on the lookout for essay grades in maybe an hour and a half. Have a good one, everybody, and I'll see you all next time.
Good night.
All right. Good night. Thank you.
Night.
Thanks.
Later, thank you.
It was good to see everybody.
Yeah, nice.
Yeah, I'm glad everyone made it. This was actually, I think, the most people we've ever had at one time. It was definitely good to see everyone here. Stay safe, the rest of you who are still here.
You too, Professor. Thanks.
All right. Hi, Michael. Hey, Juan. Hey, George.
Yeah.
Hello.
Hey, Kwanzaa. How are you?
Thank
Juan.
you.
How are you guys surviving?